Here's a question I get a lot from my clients. Will the IRS overlook my tax evasion if they consider what I did minor? Well, I tell them this. The government has to prove 3 elements of a tax crime to hold you guilty of tax evasion. 1, you owed tax. Had you filed a true, correct return, other than the return you did file, you would have owed additional tax. 2nd, you acted willfully. The mistake wasn't a mistake. You purposely understated your tax liability. 3rd, you made an affirmative act at evasion, or you made an affirmative attempt to evade. The question that's being asked here relates to the 3rd element of this crime. How serious must the affirmative act be? The real answer here is not serious at all. There is no de minimis rule for income tax evasion. Theoretically, the evasion of $10 of income tax is the same felony as $10 million of income tax. The only difference is, under the sentencing guidelines, how much jail time you'll do over $10 versus $10 million. 0 jail time over $10, lots of jail time over $10 million. Matter of fact, the Ninth Circuit clarified that Congress did not intend to establish a hierarchy of attempts or of evasions and limit the offense to those of a more deceitful or troublesome character. That came out of U.S. versus Carlson. The scary part is there's no mathematical threshold that you must cross to find yourself criminally prosecuted. The courts merely hold here is that your understatement of tax liability has to be substantial. And again, not all courts agree on what substantial is. Matter of fact, if you live in California, the Ninth Circuit has held all the government has to do to prove this element is show that some deficiency existed. The Ninth Circuit clarified that all is necessary under this element is that a reasonable trier of fact could reasonably determine that there was some deficiency that they could prosecute on. And they could do so under a reasonable doubt standard.